Hello, everybody, sorors and friends. I am so excited to be here as a representative of the Economic Development Committee for Delta Sigma Theta Sorority Incorporated, the Contra Costa Alumni Chapter. I am honored to sit in this space and to bring to you one of my favorite topics of just helping families to get their business affairs in order. So, tonight we are going to answer a lot of questions that people may have as it relates to the trust process, the estate planning process as a whole. And our goal ultimately is to educate you to put yourself in a position to advance your family to protect your assets. So, our goal this evening is to help you understand what a trust is, what it's not, why it matters, and how it can help safeguard what you've spent basically your life building. We want to empower you with clear, accessible information so you can make a confident decision for yourself and for your family. My love for this work came from just my experience as a realtor. This is actually my 19th year in real estate. And one of the things that I noticed as I entered into the industry was that people who looked like me owned assets that they were unable to hold on to. And unfortunately, when grandma died, the house had to be sold because the controls weren't in place to protect the asset. And I knew to my core that something was wrong with that. And I wanted to commit my life's work to making sure that people were educated on what they educated and had what they need to make the decisions to protect their assets. So before we get started, I'm just going to ask for you all to we want you to be engaged in this process because this is your hour or your little hour plus. And so, if you have questions for us, we are definitely open to answering them as we want you to leave here informed. And we will also have my information and Martin's information at the end of the conversation. But if you have questions for us, we ask that you put them in the chat and we will get to them. So now, without further ado, I will open up the floor and start beginning our process, which will basically be a question and answer session in which I will allow the expert, the real expert here, Martin, to answer our questions about the trust process and what it looks like for you and for your family. So before we get started with questions, Martin, I will yield to you to allow you to do your own welcome.
Well, thank you very much, Felicia. And I also want to thank the Contra Costa Alumnae chapter of Delta Sigma Theta. I am very excited and very honored to be before you and your guests this evening to present this information. Like you, Felicia, estate planning and legacy preservation is a passion of mine. And if I have to do it one trust at a time, we are going to build generational wealth. So I welcome your questions, and I just am very happy to be here this evening.
Awesome. Thank you so much. Thank you so much. So the question of the hour, as we enter into this conversation is, what is a trust? Like, what is a trust? What does it mean to me as an individual? What does it mean to me as a single person? Can you just give us a definition of what a trust is?
Yes, a trust is a legal arrangement that allows you to select a trustee, someone you trust, to manage your property in the event that you become incapacitated or disabled or you die.
Hmm.
So when you think about a legal arrangement, I want you to think about very similar legal arrangements. An LLC is a legal arrangement. A corporation is a legal arrangement. So basically, under the laws of California and federal laws, you can create an LLC, you can create a trust, you can create a corporation. That's all it is a legal arrangement that is recognized under the law and the courts. So that's what a trust is. The
Now,
next, go
go
ahead.
ahead. Go
No,
ahead. Sorry.
I was just going to say the next question that usually comes up is, what's the difference between a trust and a will?
That's it.
And a trust becomes effective the minute you create the trust, whereas a will only comes into effect when a person dies. The similarities are that in a trust, you do determine and memorialize who you want to get your stuff.
Mhm.
And a will does that as well. The only difference is that, well, there's several differences, but the main difference is that a will has to be supervised by the court. So when a person dies, there's this process called probate, and the court is supervising how your stuff is distributed to your heirs. So I know we'll talk a little bit more about probate and non-probate, but that's the basic difference between a will and a trust.
Okay, thanks for that. So help us understand who needs a trust. So, I'm going to give you a couple of scenarios. I'm a married woman. I have adult children. Would I need a trust? I'm a single person and I have, dependent children. Will I need a trust? I don't own a house. Do I need a trust? I really don't own much. I have, retirement from my job. I may have some jewelry. I have a car. Would I need a trust? Who needs a trust?
In California, most people need a trust, even though in this scenario you mentioned that you don't have a house, but you do have belongings, you do have possessions. And what people tend to forget is that everything you own is subject to probate. Bank accounts, not retirement accounts, definitely, brokerage accounts. So you may not own a house. There's a lot of people who don't own anymore, but they have stocks, they have investments, they have jewelry, they have art, and those things need to be distributed to their heirs. So, what a trust does, the trust allows you to say exactly who you want to get the bank accounts, the retirement plans, even though you may list a beneficiary that would avoid probate and go to that person. But you mentioned that you're married, you have adult children, but no house. Well, what if you and your husband die in the same accident? Well, there goes those beneficiary designations. If you haven't planned beyond the first beneficiary, a trust would come in very handy as a contingent beneficiary. Another thing that a trust does for you, it allows people to continue to manage your assets when you're incapacitated. So think about someone who's had a stroke, and once again, they may not own a house, but they've had a stroke, they can't communicate, and now they have a 401k at their company. Who's going to talk to the company? Who has legal authority to talk to the company about that? So, through estate planning, we create documents that would allow a family member to have the authority to act in that particular event.
Can you speak to the benefits of a trust for people with minor children?
Well, with minor children, you and when you say trust, it's a cornerstone of a estate plan.
Mhm.
So it is a component, but people generally don't come to an estate planning attorney just for that one component. There's several documents that work in concert with each other. So when you speak about minor children, what we use to protect them in estate planning is actually, we do actually use a will in that case, because under California law, the will is where a parent would nominate a guardian in the event that they die. But with minor children, once again, let's say you don't have a house, you have retirement assets, you have brokerage accounts, you have stock, and you and your husband die in the same accident. Well, in that case, you have minor children, and most insurance companies are not going to give that money to minor children. They would seek a custodian, and the trust allows you to name those people as receiving those proceeds, and they can manage them for the minor children until they're at an age that you specify. Hopefully that answers your question.
Yeah, I think I asked that question because I feel like that's a very critical component when you have minor children, because oftentimes people don't plan for who will manage the finances related to that minor child. So the person who necessarily takes care of them may not be the person you want to manage the finances, right? Like grandma may love the baby, but she is a gambler. You know what I mean?
Yes,
And
yes.
so
That's a perfect example. And so, in the estate planning process for people with minor children, we would have them designate a temporary I'm sorry,
guardian.
guardian. And that would be, let's say, primary people are on the East Coast, but you just have friends here in California. You don't have relatives. So what you may do is nominate a short-term guardian. It could be family friend, neighbor that you really trust. And then that gives you time for the relatives back east to make arrangements, and you have named the long-term caregiver of your minor children, maybe someone back east. So the courts will look at these kind of things because without nominations in place, the court's going to look for, next of kin and that sort of thing. And you are literally going to have to go through a proceeding for guardianship, of minor children who are now orphaned.
So, what do you say to people who say, unfortunately, people will say, "Well, I'm going to be dead. I'm not going to worry about handling that. I'm not going to worry about handling those affairs. I'll leave that up to, my relatives who I leave behind." What do you say to that?
Right. I usually say that, this kind of planning is an act of love. It's
Mhm.
an act of putting time and effort together now so that your loved ones will not be going through confusion, delay, costs, on top of probably the emotional loss that they're feeling because you just died. So you are removing a major aspect of frustration and family bickering and all these kind of things that can happen when there's no plans that have been left to guide your survivors. So that's one thing I say. Then I say, you know, if they'll figure it out, but at what cost? Because without planning, you are going to end up, your estate's going to end up in probate. And those fees and the time and the delay really do reduce the amount of wealth that can be passed on to a generation. And the other thing is they call probate like a family divorce because it is a proceeding where everybody gets to participate and people don't get along. And now you have family members that don't speak to each other because they feel like they didn't get what they should have. And it all could have been solved by someone taking the time to plan.
So, can you sort of walk us through what the process looks like for a family that does have assets? For example, there is um, and there's a loss of life. So now this family does not have a trust in place. What's the process that they would have to go through to manage, have access to, or even dispose of the assets that were left behind?
Well, first of all, in most cases, when people have a spouse, the impact is not as great on the first death
Mhm.
because, a lot of people hold their homes in joint tenancy. And so if someone dies, that house would go to their spouse immediately. The problem would become if one of the spouses owns separate property in their own name, that property would definitely have to go through probate.
Mhm.
If they had a retirement plan without a designated beneficiary, that would be a problem. So that's when, the surviving spouse says, you know what, I better get my stuff together. I just lost my husband or wife. Now let me do some planning. But the more urgent issue is when the second person who passes and there's no estate planning in place.
Mhm.
So let's say they had a house, some money in some bank accounts, and that sort of thing. I have to wave my hand because this motion detector in my office, the light goes off. Sorry
That's
about
fine.
that.
That's fine.
Um, the second death has occurred. This family, they have even grown children at this point, and there's a house and a rental. Well, the
Mhm.
process is that someone has to determine whether there was a will or if there was no will. In both cases, the process is the same. A probate has to be opened at the county. And the whole purpose of probate is to transfer title of assets. And just think about it. If you have a house and the title has not been changed, and it's not in your name, you can't sell that house. You can't refi it. Technically, you're not supposed to be insuring it because it's not your insurable interest, it's not your property. So probate serves the purpose of transferring title to these assets and distributing them to the person who gets them. So the process is filing a petition for probate. At that point, there could be an objection by a family member. So that's when some of the mess starts. If you're lucky, there's no objection. You get a hearing in about 4 months. At that hearing, they determine if you are going to be selected as the personal representative for the estate. And usually it's your mom or your dad or another relative. So then from that month, you have 4 or 5 months where you're supposed to be gathering assets, getting an appraisal, and that's done by the court as well. After the 4 months go, you submit a petition to close the probate. 4 more months goes by before you get a hearing date and creditor claims come up. There's a lot of different moving parts, but in Contra Costa County, it's taking anywhere from, on the short end, 18 months and beyond, anywhere from 18 to 24 months. And there's a cost associated with it that is what we call their statutory fees. They're set by the state. And as an example, on a $1 million estate, the probate fee is $46,000. Now, most people who own a home here and have some savings are going to be very close to $1 million.
Mhm.
So that's 46 grand that could have been in your family's pocket as opposed to in the legal system.
So to that point, um, so what I'm hearing is that what getting a trust could probably take how much time would it
Four
take?
weeks, 5 weeks. I
So
usually quote 4 or 5 weeks.
so you could technically get a trust in 5 weeks and have it all wrapped up, giving you the ability and access to take care of business. Without a trust, you're looking at, you know, a year and a half to do the same thing, in which you would need to be maintaining the expenses of the estate, if there are any, taking care of, whatever is associated with the estate, pretty much out of pocket if there are no funds left behind, because you don't have access to the funds that normally would be associated with. What are we looking at from a cost perspective? Like, what would it cost for a family? And I'm going to throw out a family of five who owns a home. You have two individuals who are preparing to retire and have some retirement income saved. They have cars, they have, a minor child and two adult children. Like, what would the cost of having a trust look like for a family, for this family?
So for that particular family, there's still a range, whether they have no kids or it's a blended family. And I would say the range is from the low end, and people are going to hear this and they're going to say, I thought you said it was going to be whatever, but on the low end, it's like 600-700 bucks.
Mhm.
On the higher end, it does depend on how complex the trust is. For me, it would be somewhere around $4,500, but it could go even higher. And so you may ask, well, what's the complexity? Well, the complexity could be, in this situation, you said they have two adult children and a minor child. That tells me maybe it's a blended family, We don't know if there's ex-spouses involved, but they may say, we don't want this minor child to get any money if something happens to us until age 30. And even at 30, we still want someone to manage that money for them. One of our adult children has special needs, and we got to set money aside there. And our other child, we don't like his wife. And if there's a divorce, we want to make sure the money stays on our side of the family or with him. So now we've introduced some special needs planning. We need some divorce protection. We need a longer term trust to protect the minor child at least until they're 30. And so those kind of things complicate the trust. And what we tend to do is sit down and talk to people about their family. Tell me about this son. Tell me about that daughter. How many times have you been married? How many kids? So those kind of things go into a more complex trust. But
Mhm.
I liken this whole price range thing to, let's think, we're coming up on Thanksgiving. And, we all have someone in our family whose perception of their cooking abilities is better than it really is. And they decide they want to bring the mac and cheese for Thanksgiving. And for all intents and purposes, it is mac and cheese. You could call it mac and cheese. But then you got grandma who comes and she's throwing down on some real mac and cheese. So that's kind of the difference. Yeah, you can get a trust for $600, but it's not going to serve your family in the long run. Now, there may be some exceptions, and I'll give you one. A lot of our military members, the military has a legal system and they draft trusts for any soldiers going overseas being deployed. And they're the equivalent of $600 trust. They're 4 pages long, and it just says, who do you want everything to go to? And that's it. There's no structure around how they get it, when they get it, what are the restrictions, do they have to be productive citizens? There's a lot of things that go into one trust versus another. So hopefully that answers your question.
No, that's very helpful. And what I'm hearing is that, it can range from 600 to, in the
Thousands.
thousands. But it sounds much less than that 46,000 that you mentioned before, that people would have to encounter with if they didn't have one, right? Um,
Yeah, you
so that's a big gap.
that's a big gap. And you mentioned something that I'd like to expound on is the probate fee is based on gross estate. So whether you have a mortgage, it makes no difference. It can be $1 million house with an $800,000 mortgage. You still are going to be, it's going to be based on $1 million. Banks don't stop because your house is in probate. If you get past a certain number of months, they're going to start foreclosure proceedings. And so you mentioned, well, who's going to be maintaining the house and paying the mortgage and the insurance if all the funds are locked up? Generally, it's one person in the family who's been successful and they have some money and they'll keep paying it. If you're lucky. Otherwise, they're going to end up losing the property.
Mhm. So, what about if you have a family that you love dearly and you do want to, get your affairs in order by getting a solid trust in place? However, you don't have responsible members in your family to manage the trust. Who could you what's allowed? Who else
Okay.
could you bring to the table to take care of the business that you feel like, your family members may not be able to take care of it in order to get your trust executed?
Very good question. And I love the word you used, what's allowed,
Mhm.
because trusts are very flexible and almost anything is allowed within, certain frameworks under the state. So when people want to do planning and they don't have anybody they trust, and it could be maybe they don't have any more living relatives. And this happens quite a bit. So there's a class of professional called a California licensed fiduciary, and they are licensed and bonded by the state, and they are people who manage property, they manage assets, they manage investments for individuals who have either hired them or families that have hired them. It's very much like, Wells Fargo has a trust department, all the major banks have trust departments, and they could be the trustee. Unfortunately, those large institutional trust companies, they're looking to manage assets. So generally 3 to 5 million you need. So, but if you go with a licensed professional, there's hundreds of them in the state. You could hire a CPA to be your trustee, an attorney. So there's no legal definition of who could be a trustee. But in the trust that I draft, if a person no longer can manage their own trust, the trust will state that the person either has to be an individual, a CPA, or an attorney that is not subordinate to a beneficiary. So you wouldn't want someone's cousin maybe being the trustee if the other cousin is the beneficiary, because you're not sure that that person is going to be fair or maybe knows how to handle it. So I would look at a professional fiduciary.
Okay, great. So what if someone currently has a trust? What do you recommend? How much time? And what do you recommend people? When should they reevaluate the trust? When should they look at it again? And then what kind of things should they consider in terms of like life changes to update a trust?
Disability decline. So if their mental faculties are declining, if they now have a disability, if there's a death, it could be a death of a spouse, a death of a child, anybody named in their trust, if that person dies, they should be making some changes. Those are the kind of things. Marriages, if one of their children gets married and the child's named in the trust, they probably should think about possibly changing their trust if they feel like they want some added protection. So just in that scenario right there, let's say you have two adult children, you had a trust done, 10 years ago, and you're leaving everything outright to those two children. One of the children gets married, you don't like the spouse has issues, you may want to consider revising your trust to leave the assets to that one child in a trust that is managed by a trustee for a certain amount of time or for life of that child. And if that child dies, the money goes to only his children and not the spouse. So that's just an example of needing to make some changes. But the tax laws change frequently. So I would say at a very minimum, people should be looking at changing their trust. I'm not changing, but reviewing their trust every 2 to 3 years.
So if someone wants to make a change to their trust, do they have to go back to the person who created it, or how does that work?
They can go to any licensed professional who knows what they're doing. And what I mean, legal professional as far as changing the trust. So there's people who come to me all the time with a trust that was done years ago, or their attorney's not practicing anymore. Their attorney has died. They don't know who the attorney was, because they have a trust that, their husband or wife did some time ago. So they could come to me, I could review the trust and make changes. One of the issues is most people who come have trusts that are really old. And I hate to say it, but it's like, yes, you need a new trust. And it's not because I just want to sell a trust, but there was a major law change in 2012, in 17 after Trump first took office, and in 22 there were more changes that really affect trust. So that's why you need to get your trust done. And I'll give you one more example. The change that took place in 2012 really affected a lot of trust for married people. And so if a spouse dies and they still have that old trust in place, many of them require that a separate trust be created and accountings be done and tax returns be filed for that separate trust of the deceased spouse. And people don't know they have these ticking time bombs in their estate plans.
So, going back to the trustee or the assigned professional, the fiduciary for the trust, um, can you talk about how the compensation for that, right? Like, isn't there that person is compensated for their efforts?
Yes, yes. Most professional fiduciaries are either charging an hourly fee or a percent of assets. So let's say the trust assets are worth, $3 million. They may charge 1% annually on that $3 million. Some other professional fiduciaries will charge hourly, and that could be 125 to 150 an hour, but it's only when they're doing work. So if they have to, write a check every month to the beneficiaries, if they have to go check on the beneficiaries, they're only charging for that amount of time. The
Okay.
ones that are charging a percentage of assets, yes, that's being charged all year long, but then you're not paying for every little thing they do. They just get this lump sum or a quarterly payment to do the work that they're tasked to do.
So, can you clarify for those that do take on those responsibilities, what kind of power or responsibility are they, held to? Like,
Given.
what can they do? What kind of power are they given?
Well, a lot of it is going to, I see there's a question there about adding children to the title. We can talk about that. Um, a lot of the powers are granted in the trust. So generally, the trust will give them the power to do everything that you would have done, except change the provisions of the trust. So if let's say you left and there was rental property and you have beneficiaries, um, the fiduciary is going to manage the property just like you would. They would collect the rents, make the repairs, anything that you would normally do to your assets the trustee is powered to do. Now, that's part of customizing your trust because you may want to add additional powers. You may want to subtract powers away. You could appoint a trustee only to manage one asset for you and have another trustee manage everything else. So it's very broad. Um, Real estate powers, contracting powers, mortgaging powers, defending the trust in court. I mean, it's so broad. Now, as far as protections are concerned, the state of California enforces a fiduciary duty upon trustees, whether it's your uncle who's the trustee or whether it's a professional fiduciary. And so, who brings this to the state's attention? The beneficiaries. So when a person dies, and they're the last spouse to die, um, technically the trustee is supposed to notify the beneficiaries, give them a copy of the trust if they ask for it. And so now, let's say you're an adult beneficiary, you're reading the trust, and it says that you're supposed to get X, Y, and Z every quarter. If you're not getting that, that's when you file a claim, and it's usually done by first writing a letter to the trustee stating, hey, you're not following the trust. If they don't listen, then the next step is going to court, most likely.
Okay. So we have a couple of questions here in the chat. Before I continue my questions, we have a question about adding I'm imagining your adult children a title. Is it better to put the home in a trust or add your adult children to title?
Adding adult children to title is one of the worst generational wealth building techniques there is. And that is because when you add a child to title while you're alive, you are depriving them of a very huge tax benefit that they would normally get if they were receiving the house when you die. So I'm going to use very simple terms. Many people bought houses when they were $60,000 in Oakland, Richmond, Vallejo, where I grew up. $60,000. Now you as a realtor, you know these houses are worth 800,000, a million. Okay, so you add the child to the title and then you die, they get the house. And if they sold the house, their basis on that property would be the 60,000 that you bought it for. And so now if they sell it at a million, they are going to be paying capital gains tax on $940,000. Okay.
Mm,
Versus if they receive the house in the trust, the day you die, they get what's called a step up in basis on that house. And if that house is now worth a million, that's what they receive it at. And if they sold it the next day, there would be no capital gains tax. And now they have $1 million in their account, tax free.
Now, this is what they need to teach in church, in
That's right.
school, and all of the things because people miss this fundamental fact because everybody feels like they know or they've heard, and people don't talk enough about the mistakes that come as a result of not consulting a professional. And I get it. I grew up in an era in which we were, we're not paying them all that money to do that kind of thing, or and it there's value in bringing a professional to the table to handle your affairs to this extent. So we do have another question in the fact that in the chat that talks about that. It's a question that says, how effective are self-prepared trusts that are offered through an employer, or would you recommend meeting with a professional? What would you say there?
Well, I grew up in an era where we learned that you get what you pay for. And even if you get a trust that's offered through an employer, it's usually like a legal insurance plan or something like that. And they will satisfy some of the most basic estate planning needs, but they have gaps. And I'll give you an example of a gap. So I had a young man come to me whose mother had died in 2018, and she had a trust and she had three properties. All the properties were in the trust, and she had a bank account that had a lot of money in it. Well, the trustee, after she died, was her sister. And her sister did not properly administer the trust, and then she died. So the young man brings the trust to me, and there's no trustee because the mom died and now the aunt has died. And the bank would not let him get the money out of the bank. So that was a 6-page trust. And not that you'll get that through a legal plan. It might be 30 or 40 pages. But what happens is they're not covering all the bases. So I say consult with a legal professional who will talk to you about your situation. And even if cost is an issue for you, there's probably a way to get your wishes met within your budget.
Mhm.
And so I really think that we as a culture, and this is not even race related, this is just culturally, a lot of people are afraid to invest and pay for professional services. They want to get advice from their cousin who doesn't know anything. And I heard this and I heard that, and they need to get professional advice.
Mhm. So we have a question here. Does the trustee have to be an adult? I'm imagining yes.
The answer is yes,
Okay.
as long as they're over 18, actually. But I would not. Hey, let me tell you, I have grown adult children, trustees come to me who don't know how to balance a checkbook. They don't keep good records. They can't remember why they spent this money. And the other beneficiaries are like, we don't know what's going on. We don't know what he did with the money. So they don't have to be, you don't have to be a rocket scientist. You just need to be someone who can be well organized, keep track of things, and the trust will allow you to hire professionals to help you as a trustee. So
Mhm.
you could be an adult child and you can hire a CPA to help, you can hire an attorney to help you administer the trust for your parents when your four brothers or sisters are beneficiaries as well.
Yeah, I know for me, my trust itself evolved as as time went on, and especially as my adult child, her lifestyle sort of stood out. And I was like, wait, you can't give this girl too much money up front because she gonna be in Miami. Like
Right, right.
she
Make you
gonna,
move to
drinks
Miami.
on her. Exactly.
Yeah.
So I feel like, that's a critical part that people sometimes overlook when they're thinking about, leaving assets to their beneficiaries. Yes, exactly. I mean, there is no other place for my assets to go, for most parents. But the trust allows you to do so with precision and with wisdom, opposed to, dumping a whole bunch of assets on someone who
Mhm.
may not be responsible, or familiar.
Correct.
Um, I want to pivot a little bit and talk about some of the critical documents that people need to have in place as part of the entire estate plan, like some of the things that people would need to consider. Can you just sort of mention some of those critical documents?
Yes, the first one would be a pour over will. So even if you do have a trust, we do recommend people have what's called a pour over will. And the role of the pour over will is to take anything that's in your name on the date of death and pour it into the trust. So, for instance, you might have a person who refied a property. The title company or the bank most likely did not want to refi the property in the name of the trust. They want the contract to be between individuals and the bank. So they make you take the house out of the trust, you do the refi, and then nobody puts the house back in the trust.
Mhm.
So in that case, if you die and the house is outside the trust, the pour over will would allow your personal representative to put the house back in the trust. There's a few steps we have to do, but it's better than going through a probate on a house. So that's very important, and it's kind of a safety net. The next item would be a durable power of attorney. The power of attorney is a document where you grant someone else power to act on your behalf. It can be as narrow or as broad as you want. We create very robust, detailed powers of attorneys that are probably 25 to 30 pages and very broad, but there are very short ones. So you could write a power of attorney just for someone, giving them the power only to sell this particular property or to talk to your employer about your earnings or something like that. Um, the power of attorney does cease when you die, but it's critical to have one because you can put property in a trust, but there's so many aspects of life that revolve outside of the trust. Like I
Mhm.
just mentioned, talking to your employer. What if you have a stroke and you need someone to get into your office at work to get your stuff? Well, the power of attorney would give you access to speak to your spouse's employer. And there's various other um, purposes for the power of attorney. We do a living will, which is a healthcare directive. It's kind of a funny name, but it's basically telling your doctor that if you are in a vegetative state and death is imminent, that you don't want to be kept alive, or you could give some criteria. You only want to be kept alive, 3 more weeks. So that's another critical document. An advanced healthcare directive is critical, where you're naming a healthcare advocate to make decisions for you if you're unable to make medical decisions. What else? Memorial instructions are important. A certificate of trust is another document. Uh, uh, Personal property memorandum, where you're stating that you want to leave this particular item to this person. That stops people from leaving the funeral, going to your house and taking what they want. So there's some legal force behind that. So those are the critical documents: the trust, the power of attorney, the will, the healthcare directives, the assignment of personal property.
And those all comprise the estate plan.
Yeah, a comprehensive estate plan.
All right. All right. And I think the part that always stands out to me is that power of attorney, because people are very familiar with that. But I've heard an attorney say once, when the person dies, the power of attorney dies. So don't go to the bank
Right,
after they dead using
right.
that, because now you're breaking the law.
They will say, like Martin used to say, get to stepping, because you're not
Right,
getting any
exactly.
money in here.
Exactly.
Around the power of attorney and the healthcare directive, those two alone are very powerful, because if someone doesn't have a trust and they lose capacity, the next step without those documents would be what's called a conservatorship. So if you
Mhm.
have an elderly mom or dad, and you need to take over their finances and do things for them, at the very minimum, if you have a power of attorney and a healthcare directive, you can avoid having to do a conservatorship for your loved one.
Okay. Okay, I want to just thank our audience for just engaging with us and giving us these great questions. Someone is asking a question that I think I can assist with, but I will yield to you as well, Martin. They're saying, can you speak to beneficiaries who inherit a home that has a mortgage and the need to refinance the home? The beneficiaries need to have good credit. Absolutely. There is no bank that will allow you to refinance a property if you don't have the credit to support it. And that's one critical piece about leaving houses. Just because someone has left a house in a trust does not mean that the person they're leaving it to has the ability to maintain what it will take to keep the house going, right? Making that mortgage payment, paying taxes, all of those things. So, those are other things that people need to consider when they're sort of funding a trust and figuring out, like, am I going to, expect someone to, or is there anyone capable of managing this asset and continuing to make the mortgage payments? Because just unless you have insurance that will cover the balance of the mortgage, some people do and some people don't, that responsibility is still there, and the bank does not let it go. They don't say, just because they're deceased, you can continue to make the payments in their name, mainly because the bank has loaned the money to the deceased. And now if you're going to keep the house, you need to qualify to keep the house. Um, do you want to add anything to that? That's just based on my experience.
No, that's a very good point. Life insurance is a major way to pass on generational wealth, and it could help save the house.
Yes, absolutely. It says, can you explain the difference and benefits of revocable versus irrevocable trust and how to use a holding company to further protect your assets?
We're not going to get into holding companies tonight,
Okay.
but the main difference between irrevocable and revocable is that the revocable trust can be changed. So that's what they mean by it's revocable. You can revoke it. It can be changed. Irrevocable means it cannot be changed. There are benefits to having a revocable trust, primarily for very wealthy people, because it allows them to take assets out of their name and And they do it primarily to reduce estate tax. So, for instance, if someone was worth 100 million and they needed to get down below 30 million to avoid estate tax, they may create a irrevocable trust, transfer 70 million of assets for the benefit of their children into that irrevocable trust because they can afford it. They put 70 million in there, they still are worth 30, and they 85, 90 years old, 30 million is going to last. And so that chunk is now out of their name, out of their control, and it provides a great benefit. But technically, there's no changes that can be made to that. And so a lot of people come to my office and say, I want asset protection, I want this, but they're not willing to give up control. So
Mhm.
that house would have to come out of your name and into another person's name as trustee, and you cannot benefit from that asset any longer. So those are some of the primary differences between revocable and irrevocable.
So we have a question here that's a little specific, and I don't know if you can give a general answer, but it says, can you speak about the laws that may have affected trust in 2017 and 2022? I don't know why those years in particular, but I'm going to let you take a shot at it. And
Well, one law that changed, particularly in California, is that Medi-Cal recovery can only come from probate assets and not assets in a living trust. So prior to that, if you had a house that was in a living trust and you were a Medi-Cal recipient, let's say you had to go live in a nursing home and your spouse is already deceased, when you died, Medi-Cal would come after those assets, even if they were in a trust. But the law changed in 17 that says the recovery is only limited to probate assets. And probate assets are assets that are in your own personal name. So when you have a trust, the assets are in the name of the trust, and Medi-Cal doesn't come after those. There was also some changes that dealt with retirement plans and how they affect trust. It's fairly complex, but it basically stopped the ability of certain beneficiaries of stretching retirement plans um, through their lifetime and now have limited the distribution period to a maximum of 10 years. A lot of the other changes are very complex in trust, and most people are not affected by them.
okay. So it looks like we have a question. I think you may have covered this, but they're asking what's the difference between a house and a trust versus a house and a will. And I think that just depends on what they plan to do or if the person is alive or deceased. Is that right?
So I think they were saying, what's the difference between having a house with a will versus having a house with a trust?
Yes.
So with a will, you can, in your will, say that I want this house to go to my three kids, and that's fine and dandy. But the probate is going to have to be opened. And if there's no objections and if it's a very clean probate, it's still going to take about a year. But at the end of the probate, either there's two things that can happen. Either the personal representative will then deed the house to those three kids, or as a part of the probate, the court can just order that the title be changed. So you're going to go through probate, but at least the house went to the kids the way you wanted. In a trust, the same thing can happen, except it's not going to take a year, and you can put some other controls around it. And the other thing I forgot to mention, a major difference between trust and will is that the trust administration is a private affair. No one knows about it other than your family members and the trustee. Whereas a probate is public.
Hmm.
Anybody can go sit in on the hearings. When the petition is filed, there is an inventory and appraisal of assets. That's public information. So what tends to happen is the beneficiaries that are named in the trust, they start getting solicited, and people start having cousins and relatives come out of the woodwork that they didn't know they had. So if you want privacy, you need to have a trust versus a will. Let me throw in one last thing about not having a will. In the state of California, there's a plan that says who gets your belongings if you don't have a will. You still go through probate, but the difference is the distribution of assets will now be based on a flow chart, and it's basically if you have a spouse, it goes to the spouse. If you have children, some of it would go to your spouse, some of it would go to your children, depending on what the property is and whether it was community property or if you had a separate house that you owned. And so without a will, you don't have control of who gets what. And you may have a brother or a cousin or someone who you don't want to get anything, but because of the way the flow chart goes, they may end up with something. And Felicia, I think you mentioned the story about someone whose property went to an
Yes.
estranged relative.
So I had a client who had a daughter, and her daughter was an adult. And so she came to me because her daughter had passed away. The little girl was 32 years old, died unexpectedly. Her daughter owned a house. She bought a house, responsible young lady. And she passed away, and her house was not in a trust. The young girl was the only child of my client, and her father was estranged, so she hadn't seen her father since she was 2 years old. But when she died, and that house was not in a trust, her mother had to go to court. And surprisingly, her father actually, petitioned for his portion of the estate, which according to the law he was entitled to because he was her father. She didn't have any children. And this woman was devastated to know that this man, the father of the daughter, was entitled to this estate, and he had not had a relationship with her since she was 2 years old. And it was because there was no control in place. There was nothing to stop that. And it was so eye-opening to me because to have to tell this woman, not only can I help you right now, right? So she was maintaining this house, and she was, because she was going to sell it, but then she found out she had to go to probate. So she's keeping it up and making the payments and all of that. And then this father surfaces, and long story short, I sold the house, and the father got 50% of the assets from this young girl. It was devastating to watch.
Yes.
Okay, so going back to our questions, we have a question that says, could trust assets be paid out through an annuity to prevent overspending by beneficiaries?
Yes, but you could do it without even doing an annuity because the annuity, there are some costs associated with an annuity. But I have a case that I'm working on right now where the couple says they want the kids to get $2,000 a quarter. So there's four kids. If this couple dies, there's probably going to be 2 million in cash, and then there's some houses. So they basically set it up that they want quarterly payments of 2 grand to go to each of the children until they're 40 years old. So that's an annuity right there, a stream of payments, periodic payments until the person dies or the money runs out.
Okay, thank you. Let's see. We have a question that says, do you recommend a general age that beneficiaries should receive money? And she says, my mom had stipulations around age, military, or completion of college education. Do you recommend that?
Only if my client wants that in
Okay.
their estate plan. So, there are people that put conditions, finishing undergrad. I had a lady that wanted her kids to go to graduate school. And then I'll throw in things like, well, what if your kid's just a great artist? I mean, really a great artist, and they don't go to school. So, that's kind of the back and forth and counseling and guidance and making people think. Sometimes people say, I hadn't thought of that. So other people will do age ranges, 50% when I die, and then 10% a year until they're a certain age. So I only recommend it if people want to do that. And I'm good about telling people that's a bad idea. That's going to cause this. So I'm not just going to let them do whatever they want if I don't think it's going to, be good for their family.
Mhm. My daughter has a friend who her grandfather had a large estate and he wanted it to go to his grandchildren. Um, but he had created the trust a while ago, and his trust included that they had to be college graduates in order to
Mm,
receive the money. And
yeah,
there was a grandchild who, just wasn't the student, and they had 10 years after high school. I mean, it was really specific. But we watched him just sort of get his degree.
that's
Um,
right. I'd say, let me go to college right now.
we watched him get his degree because it was a lot on the line.
Hmm.
So we have a question about married couples. So if you're married, you mentioned those 5 or 6 documents that were necessary. For clarity, are those documents needed for both? Is it part of the estate plan, and does it include both parties, or is it for each of them?
It's for each of them. So
Okay.
when I do a joint trust, there's one of those documents for each person. There's only two documents where you only need one, and that is the trust itself and the certificate of trust. That certificate of trust is your proof that you created a trust, and you can go to the bank, have your accounts retitled into the name of the trust without having to take your private document down to the bank. So that's what the certificate is. Otherwise, everyone gets a power of attorney, each person gets a healthcare directive. So both partners would have their own documents.
Okay. So we have a question here that is seems very specific. So I will just read it as is. The initial question was, can limitations be put on the trust or the trustee on the necessity of hiring an additional attorney frivolously? And then I asked her to expound, and she said she experienced a trustee who was managing the trust and then hired a lawyer supposedly to help her manage and disperse assets. However, she did not disperse assets timely, and many were not dispersed at all. In short, she hired a lawyer, which was paid for by the trust, but assets were still not dispersed properly. So it is believed that there was a misuse of funds for her lawyer, and that's the extent of it.
Well, in general, I'll say that most well-drafted trusts do give the trustee the ability to hire agents, CPAs, attorneys, property managers, you name it. And that's important because depending on the amount of the assets, um, you want professionals doing this because the trustee has a fiduciary duty to do what's in the best interest of the beneficiaries. And the beneficiary could come and say, why didn't you hire a CPA to do this? Why didn't you get an attorney? You're blowing the property. So it's kind of a catch 22. But most trusts have an accounting requirement that at least annually an accounting has to be done, and it's a probate code approved accounting. It's not just a little spreadsheet they put together. It's like hiring a CPA to go through all the expenditures, all the income, and that report is sent to the beneficiaries. So if there were attorney fees in there, the accompanying narrative should explain why an attorney was hired, what they did, and that sort of thing. And if that doesn't satisfy the beneficiary, then the beneficiary is going to have to file suit or do something. But then that's money that they're spending as well.
Speaking of money, how are probate fees paid? Are they upfront, out of at the end? How does that work?
Very good question. I had a case recently where this person did not have the funds to cover the probate fee because the only asset was this house. So the probate fees are payable at the end of the probate, but the probate will not close until those fees have been paid. So for instance, you have this house, it's in the probate, and the beneficiaries want to keep it in the family. They don't want to sell it. Okay, well, where are the fees coming from? And if you don't want to sell the house and that's the only asset, someone's going to have to come up with the money. Now, the probate fee is split between the attorney and whoever the executor is.
Okay.
Many family executors will waive their fee, so they don't have to pay that out, but the attorney is definitely going to want to get paid. So you either have to get cash out of the estate or someone has to pay the fee and get reimbursed.
Mhm. So I remember I've heard of situations where um, trust that are contested. So how does that work? Like if people, if someone has a trust and they leave behind, their wishes as a result of the trust. But if people contest it, how does that work? Like I've heard of in the past, like people will put in the trust, if you contest this, you don't get nothing, or if you contest this, you get $1, or, stuff like that. How does that process work for trusts that are contested?
So there's a clause that is put into most well-drafted trusts that basically says that if the person contests the distribution or the gift, then they get $1 or zero. But if they're contesting the validity of the trust itself, that's a different story.
Hmm.
So most people are not contesting the gifts because they're going to get zero.
Hmm.
So, if somebody says, you're going to get 100,000 and you wanted two or three and you contest that, you're going to be out of luck. But if you're contesting that, you know what? I don't think my mom, that's not her signature. She wasn't in her right mind. There's
Mm.
no way this trust could have been drafted and executed. That you can go to court on. You can file a claim. You basically are filing a lawsuit.
Okay. So we have a question here. Someone lives in California and they own property outside of the state. They want to know what's the process to add the out-of-state property to an existing trust here in the state or in the state in which they reside.
That sounds like a familiar question, and it's very easy to do. You draft the trust, and then during what's called the funding of the trust, that's where either I would have an attorney in that state draft a deed and record that deed in that state. So basically, it's retitling that house in a different state into your trust. And for the most part, it's very easy to do long distance and remotely. There's just a few counties in the country that they don't have remote recording. You got to mail it in. And I'm talking like some of the podunk counties out there, Florida and some of those places where you literally need to find someone there to take that deed down to the recorder's office.
So if a person acquires a property through a trust, inherits a property, what are the tax implications of that?
Well, when someone dies and they leave the house, as I mentioned earlier, there's a step up in basis. So if they literally sold it the next day, there would be no capital gains. And if they've sold it, there's no property taxes anymore. The issue becomes when people inherit the property and it appreciates and keeps growing. So if you inherit an $800,000 house and you don't sell it till it's 1.5, you're going to be paying the same old taxes everybody else would. Unless if it was your personal property, I mean, your personal residence, you would get the exemption that comes. But otherwise, you are going to be subject to reassessment of property taxes if you don't meet certain criteria. So if someone dies and leaves a house to their child, if the child moves into the house and makes it their primary residence, then in California, there's a exemption of $1 million of property tax value. And so that works out if you're going to live in that house. But a lot of times, adult children already have their own house. And then mom and dad leaves them a house somewhere they don't want to live or the neighborhood's no good anymore. They're not moving to that house. And some people will try to submit paperwork that says they're moving in, but that's another can of worms.
Mhm.
So hopefully that answers the tax consequence
Yeah,
um,
it
question.
sounds like I think so. Um, all right. Well, Martin, this has been amazing. I really appreciate your time and the conversation. Um, if someone wanted to, like, this is a lot of information, right? And clearly, you get paid the big bucks because you have all the answers. But if someone wanted to, um, if this is overwhelming for them, where would you recommend that they start?
I would recommend they start with just a conversation,
Okay.
either any estate planning attorney, or if they have a financial advisor, talk to the financial advisor about, the basics of estate planning. Estate planning is a component of financial planning. So if you do have an advisor, just say, hey, what can you tell me about a trust or those sort of things? Now, they're not going to be giving legal advice, but at least they know the framework. And some people may feel more comfortable starting there to kind of get an unbiased um, introduction or opinion. But if you feel comfortable seeing an attorney, someone like me, I offer free consultations in my office. And we'll talk about your needs, your goals. I do kind of what's called Trust 101. When people come in, I ask them, how much do you know about trust? A
Mhm.
lot of times they say a little bit, but go ahead and give me the basics. And I walk through. So at least have a conversation.
Mhm.
And that's where you would begin. You got to get out of the fear. You got to seek some professional help, but start the conversation. And there's a lot of information on the internet these days. So those would be the places I would recommend.
Okay.